Hello, everyone, and welcome to yet another edition of Uncivil Law. I hope you are having a great day. And we are here with our continuing coverage of the Victor Mignogna versus Funimation Productions, Jamie Marchi, Monica Rial, and Ronald Toy case out of Texas. Very exciting. When we last left the action, we were discussing Vic Mignogna's oral arguments, or more properly, his attorney's oral arguments. Ty Beard on the issue of dismiss. We did the entire transcript, we reviewed it, and we offered some comments. And we also have covered both the initial pleading, the initial response, and the motion to dismiss under the Texas anti-SLAPP statute and its response. So we are reasonably well informed as to what's going on. And I have not yet read this brief. This is Vic's brief on appeal. It is 71 pages, but I think some of that is appendix. And we are just going to read and cover as it goes. And brief summary of the facts: that Vic Mignogna was, and still is as far as I know, a voice actor. He does some voice acting work for Brody, I believe it is, on Dragon Ball, among other spots, of course. He goes to conventions. He is a notable person in the community of voice actors. And he was accused of improper behavior, sexual harassment, that kind of thing, both in general and by some of his coworkers. Funimation did an investigation. He was fired. And it has become another instance in the Me Too story, that this person arguably was unjustly smeared by a overzealous bunch of people who are jealous versus perhaps did something wrong. And what my conclusion was on initial read of the initial filing was I thought that Vic had a serviceable case. I wouldn't go so far as to say plausible, but I'd say it was serviceable or workable. I thought there were some things in there that definitely could rise to defamation. I thought there were some things in there that could be issues of tortious interference with business opportunities. And then my conclusion was that his attorneys pretty much poached the case. Whatever workability he had disappeared in the long ago. This was made abundantly clear to my mind when we covered the oral arguments in the Texas State Court, where Ty Beard was not exactly well equipped, did not have answers, and at one part, more than one part, seemed to be misleading the judge and or lying. It wasn't going very well for him. I saw, at least from my perspective, that he was getting quite a bit of slack from the judge, and as things went on and on and on, it seemed to me the judge's patience was wearing thinner and thinner and thinner, and by the end of the oral argument, things were going pretty much down the toilet, because that's kind of what you would expect as the judge becomes increasingly frustrated. And the opposing side was professional and did their job, and so I was like, yep, this isn't going anywhere. It didn't go anywhere. He lost all of his causes of action. He's suing for relief because he thinks the trial court messed up. They're suing, I think, on the basis of they want more money for the damages under anti-SLAPP. So we are going to read this and see what we have to say, and we are going to try to decide whether or not the trial court messed up in any part. Now, I think Vic's best arguments, without reading this in advance, Vic's best arguments are threefold. One, his trial counsel messed up. Since his trial counsel is the one also doing appeal, I'm guessing that is not the argument he's going with. Unfitness of practice or negligent representation. So we're not going with that option. Next option is that the trial court messed up in some way by failing to enter certain evidence that should have been entered into the record, or by failing to consider certain evidence that was in the record, but they failed to consider it in some way by failing to give it the deference that was due. This was some of the murmurings I heard that were going to be the basis of the argument in between the time of the trial court and between the filing. This seemed to be the direction that they were going to be going, that there were some filings that were submitted in binders that the judge actually didn't read or didn't consider or would have gone to other things or so forth and so on. So that the judge failed to admit things were the things on the record he failed to properly consider. So, as you might imagine, it's somewhat difficult to overturn trial court decisions. You have to show some sort of error. You have to show some sort of reversible error by the court that they made a mistake somewhere along the line. So, and we're going to see what happens. So let's get started with this. Very exciting. And thank you for the 31 of you who are joining me. So we are here with this appeal. Yes, Uncivil Law is in fact a lawyer. Yes, I am a lawyer. I do intellectual property work primarily, but I am a lawyer. I'm in Virginia, but in 2 weeks I'll be in Texas. So can I call myself a Texas lawyer? Is it too soon for that? Since I'm not admitted to the Texas bar, let's refrain from that. But I'll be a member of the Texas bar before too soon because I'll waive in like everyone does. So I'll submit my stuff, yeah. But yes, I am a lawyer. Okay, so we got all of our fun stuff. All right, so we got a table of contents. It's nicely formatted. Statement of facts, summary of arguments, trial court dismissing for defamation is reversible error. Okay. Then we got some tweets. All right. Trial court dismissing against for tortious interference was reversible error. Trial court dismissing for tortious interference with prospective relationships is reversible error. Interesting that there's only 2 points here on the existing contracts, or 2 pages on existing contracts. That would seem to be a little bit longer. And this was one of my criticism of Ty's argument in the trial court stage, because the trial court asked him essentially what contracts were interfered with, and Ty couldn't seem to really answer that question. He couldn't say, it was the contract, it was the X contract with Y, Y con on Z date. He couldn't say it was this contract, this contract, this contract, this contract. He kept referring to them very amorphously and very generously. He didn't say, my client had an agreement, written or otherwise, with this person regarding this event on this date, and those were the ones that interfered with. So, it wasn't brought up in the trial, and I'm disappointed it doesn't seem to be brought up here. Why am I waiving in? Why wouldn't I waive into Texas? I'm already a member of the Virginia bar. If I want to be a member of the Texas bar, I have 2 choices. I can either take the bar exam again, or I can waive in. So why wouldn't I waive in? Because it's a ton easier to waive into the Texas bar. So please waive me in. I've been a practicing lawyer for more than 5 years. I'm in good standing. Please let me be a member of your bar. So that's normally how lawyers become members of other courts, is by waiving in. Yeah. Now, why is it called waiving in? I don't know. It's probably called something else formally. I just call it waiving in. It's, I don't know. I guess because you're waiving the bar exam. It's a waiver of the bar exam, because normally to become a member of the bar, you have to take the bar exam. So you're asking for a waiver. So a waiver is just you want something not to apply. That's what a waiver is. So when you go to a health club and they have you sign a liability waiver, for example, you're waiving the liability they would otherwise be responsible to, right? So that's a waiver. So I'm asking the Texas Supreme Court for a waiver. It's like, I don't want to take the bar exam. Please let me be a member of your bar anyway. So that's why it's like I call it waiving in, because it's a waiver. So yeah. That's as far as that. That's why I would think it's called a waiver. I never really thought about it, but now you made me think about it, that's probably why. Okay, so reversing trial court dismissing for vicarious liability is reversible error. Vicarious liability is because A is guilty, B is guilty, therefore C is guilty, right? You're going down the chain, right? So you're showing responsibility. So this is respondeat superior. This is employee responsibility. This is saying that the employer is responsible for the work of their employees. That's vicarious liability, or if I've taken on responsibility for someone else. Trial court dismissing against appellants for appellees for conspiracy is reversible error. Conspiracy is not a separate tort. It is something, you can only have a conspiracy to do something that's otherwise unlawful, right? You can't have just a general conspiracy. That doesn't even make sense. It's a conspiracy to do something else. Like, technically speaking, you and I right now are in a conspiracy. We're in an agreement to engage in something. For example, this live stream, but it's legal, so it's not a problem, right? So it's a conspiracy is agreement between two or more people with an overt act by at least one of them. It's like, yeah, but it's not illegal in this case. So if it's not illegal in that case, it doesn't matter. Trial court's refusal to consider appellant Second Amendment position is reversible. Appellees did not satisfy their evidentiary burden because trial court should have struck evidence attached to their motion to dismiss. Okay. Improperly entered evidence. All right, fine. There's a motion to dismiss, and order to pay legal fees and sanctions is reversible. Okay, fine. Yeah. How dare Uncle Blackleaf bring logic to our silliness? Licky Glock, someone asked me a question. Why is it called waving in? I'm like, oh, I've never thought about it. Why is it called waving in? And I'm like, okay, well, here's probably why it's called waving in. Yeah. All right, so then we got an index of authorities. This is very common to see in appellate practice. This is how it's written, more or less, everywhere. So yeah, we got in alphabetical order and then the page numbers that follow. Yep, no problem. Then we got some statutes that apply. And then we got some rules of procedure that appear, or rules of evidence that apply. Okay. Statement of the case. Victor Mignogna sued Funimation's Jamie Marici, Monica Real, and Ronald Toy for defamation, conspiracy, tortious interference with both existing contracts and prospective business relationships, and, as the Funimation Productions, only vicarious liability. Right, because Funimation is the only one who could possibly have vicarious liability. Vicarious liability is because they're the employer of these people. So if it's if the person who's employed in the business caused damages to you, then the person who owns the business is responsible, right? Vicarious liability. Pretty simple. But they have to be acting within the scope of their official employment and a whole bunch of other stuff. Appellees file motions to dismiss under the Texas Citizens Participation Act, the Anti-SLAPP Act. After the hearing, the trial court granted appellees' motion and dismissed all of appellees' claims with prejudice. I'm going to make my camera a little smaller. Yeah. After subsequent hearing, the trial court ordered appellants to pay attorney's fees and sanctions. That's basically what happened, yes. Yeah. Issues presented. The trial court dismissing against appellees for defamation is reversible. For tortious interference with existing is reversible. Tortious interference with prospective is reversible. For vicarious liability is reversible. For conspiracy is reversible. Refusal to consider the Second Amendment petition is reversible. So that's going to get into issues as to timeliness, among other issues. That should be interesting. The appellees present legally insufficient or factually insufficient evidence to satisfy their burden, and trial court finding otherwise reversible. Trial court ordering appellants to pay attorney's fees and sanctions is reversible. Okay. Yeah. And Mike Mitchell points out correctly that vicarious liability, of course, is not automatic. You have to be in your official capacity and a whole bunch of other things. So, just because the Domino's delivery driver does something doesn't necessarily mean Domino's is responsible. You'd have to ask if they're acting within the course of their employment. So if the Domino's delivery driver runs into you with their car on their way to deliver pizzas, then yeah, Domino's is responsible. If, they, on their off time, punch someone in the face, then no, Domino's isn't responsible. So yeah, you have to separate personal activity from professional activity. You have to separate things that are in your official capacity from outside your professional capacity, all that good stuff. Hello, Ewan. Statement of facts. Appellant Victor Mignogna is a voice actor whose voice is used for English dubbing of Japanese anime. Appellees Monica Real, Monica, and James Marici, Jamie. It's interesting that he refers to them all by first name. Interesting stylistic choice. Okay. Apelli's Funimation Productions. Funimation primarily dubs Japanese anime productions into English, then distributes the videos into US via streaming access, and has hired Vic, Monica, and Jamie to provide voiceover. Most often, the voice actors record their lines at different times and locations instead of together in a studio. At times, however, they saw each other in the offices, and Vic considered Jamie and Monica to be friends. Probably less so now, I would guess. The voice actors also appeared sometimes together at fan conventions when they participated in breakout sessions, sharing behind-the-scenes tidbits, answering fan questions, and were paid for autographs and photographs with fans, often hugging and sometimes giving kisses to their fans. Sure. On January the 22nd, 2019, Funimation initiated an internal investigation into Monica's allegations that, at a convention many years before, Vic had eaten a jelly bean, which Monica gave him, on which she had written her name, and joked that he ate Monica. Okay, personally, on just a personal level, I don't see, anything wrong with that. That's kind of funny. I wouldn't even necessarily infer from that alone, a sexual context, if that's where that's going. It's just I wrote your name on, haha, I ate you, that kind of thing. And we're going years back. I mean, just geez, really? At a convention several years prior, Vic had propositioned two adult female fans, which, again, I'm not sure why that's necessarily wrong. If they're adults, they presumably have the right to choose to engage in activity if they like, and him making a proposition doesn't seem inherently bad. I'm not sure what the problem is. And that Vic and coworker had kissed consensually at the Funimation office. Also, I don't see the problem. So I don't really see a problem in any of these things. First of all, they're all really far in the past. They're all extremely tenuous. And it's as to the consensual, why do I care? As to the fans, why do I care? And as to this one incident with the jelly bean, you've got to be kidding me. I have better things to do with my time. Why are we making an investigation over this? I don't understand. This makes no sense to me. Yeah. Yeah. Though Funimation had not yet informed Vic of the investigation, Monica's fiancé, Apelli, Ronald began telephoning and texting Christopher Sloch, hold of the Comic-Con convention on January the 22nd, 2019, that Funimation's parent company, Sony, was conducting an investigation into Vic's assaulting four women and criminal charges will soon be against Vic. That was not well argued in either the filings or in the oral argument, in my humble opinion. I don't really like the way that Ty Beard filed this in the first place, because Ty has to know the TCPA response is coming. And I wish he had done a lot more of what Tulsi Gabbard did in her recent lawsuit against Hillary Clinton. She in her lawsuit has attempted to preempt the responses she knows is coming, because they're completely predictable. And I wish that Vic's lawyer had done the same thing. He filed a notice pleading. He filed a bare bones allegation. Is it legal? Yes. Was it a good move? No, I don't think it was. I would have taken the time to try to preempt the arguments, because I know they're coming. What's the point of waiting? I know their arguments, and why not just fight them up front? And it makes me look like I know what I'm doing. So I did not like that tactical decision, assuming it was a tactical decision. Monica told Sloch that Vic was a sexual predator and criminal charges would soon be filed against him. Both urged to cancel Vic's invitation to Comic-Con, despite Sloch's objection that doing so would breach of contract and refusing to do business with Vic in the future. Otherwise, Ronald's company withdraw all financial sponsorship of the convention, and Monica would cancel her appearance and convince other Vic voice actors. Sloch complied. Okay, that seems very much like tortious interference. You have direct things from one person to another. You have direct statements made from a direct person to a direct person over a specific thing with threats induced. That, if you've shown that, that'd be tortious interference. That's fine, but you didn't make that case. You didn't have that evidence. I don't remember a deposition from any of these people, including Sloch. I don't remember that. I don't remember it doesn't necessarily even have to be a deposition. That would have been nice. An email from him that says, these are the things that would have occurred, would have been enough to get me through the door. I don't remember that happening. Like, it would, maybe this is what happened, but I don't remember seeing evidence of it. I don't even remember seeing being particularly well pleaded. So, okay, let's press on. Maybe it really was well pleaded, because this is a summary of facts, right? So we wouldn't expect like citations to anything here. This is just a review of what's happened today. So like the fact there's no like citations here doesn't really bother me. There's a few like footnotes, but in fact, we'll get into it later. That's fine. But I'm just saying, when I read it, it's like, I wish you had proved this stuff. That would have been really helpful. 2 days later, Ronald tweeted publicly, "I know with 100% certainty that Vic assaulted 4 people I love." Well, that would be defamation, potentially. I know with 100% certainty that Vic assaulted 4 people I love. Well, that's what we call a statement of fact. I know that Vic did this thing 4 times. That's a statement of fact. If it's false, it's defamatory. And like, yeah, so again, would have been nice if that had been well pleaded. Would have been nice if there had been sufficient evidence for it. Don't really remember that coming up when I read the stuff. So yeah. The next day, Tammy Denbo, executive director of employee relations for Sony, informed Vic of Monica's allegations, none of which involved abuse, assault, or harassment. I tend to agree to that. Vic explained the Monica Jelly Bean exchange was friendly banter many years ago. And I'm still like, my response would be more like, you have got to be kidding me. You cannot be serious. Really? This is what we're investigating? You cannot be serious. And the kiss with a coworker was consensual. If it's consensual, why does literally anyone care? Though Ms. Denbo admonished Vic that Sony's investigation was confidential, she and co-worker Lisa Gibson gave Monica updates. Ms. Denbo talked it through with her. Ms. Gibson encouraged her to hang it in there. Confidential with respect to what? I mean, I don't know exactly what that means. Confidential, I mean, an investigation necessarily implicates that you're going to be talking to people. So I'm not sure what confidential, like, it's between the company and the people. It's confidential in that sense. Like, they weren't exactly going public with it at that point. So it was confidential. I don't know what you thought confidential was going on. Michael said, "Is an unsworn affidavit worth anything?" It's a start, man. It's a start. Like, yeah. And well, I mean, an email. I mean, just something from him on the record. Be like, hey, I have a statement from this guy that says this and I can get it sworn. I mean, it's a start. It's a start to have. It's like, random email from the guy would be enough to be like, oh, I put that in my pleading. According to an email from this guy, he said this. I put it in my pleading. It's not an affidavit, but it's not nothing. It's evidence. It's not nothing. After Ms. Denbo informed Vic of the investigation, Ronald launched a barrage of tweets. On January 25th, I have 4 people very close to me who have had similar experiences. He assaulted them. That could be defamation. Vic is guilty of sexual assault, potentially defamation. Vic is a man with clear history of sexual deviancy. Unclear, because what is sexual deviancy? Like, unlike sexual assault, which has a much more understood meaning, what is deviancy? Like, at all, in principle. So that probably is not actionable. Funimation abruptly terminated its contract the next day. Both Anime New York City and Anime Milwaukee conventions canceled the appearances. Okay. Yeah. After Monica secretly asked Funimation what she could say publicly and when Funimation would make a statement. Again, as opposed to what? Right? This is an internal investigation. This is an internal investigation that is being conducted. They've presumably told Monica it's confidential. And she says to them, I'd like to say something about it publicly. Can I do that? What do you mean secretly? As opposed to what? Publicly? The whole point is to make sure it's going to be like not a problem or interfere with the investigation or whatever, because they've told me that it's confidential. What do you mean secretly? Like, that's a bad thing. What are you talking about? She, Miss Gibson, and Scott Barreto, Funimation's senior director of public relations, spoke via telephone. That day, Ronald tweeted, I know of at least 4 assaults. I'm glad to see conventions canceled and the truth come to light. Potentially defamatory. That day, Kawaii-Con canceled Vic's appearance. 3 days later, Monica likewise tweets the truth will come out. Not defamation because it doesn't imply anything. Ronald Laird claimed, I know without question he heard people very close to me, and he's a predator. Potentially defamation. With over 100 ladies in county coming forward with accusations. Potentially defamatory. 100 ladies and counting is specific fact. That's a statement of fact. 100 ladies have come forward. That's a fact. Even if she's exaggerating or embellishing, if the number's not like something remotely close to 100, it's a fact. If we're 80, we'll give her a slide. If it's 20, probably not so much. But yeah, it's a fact. You're making a statement of fact, so yeah. Kawalong. Kawalong? Okay, Kawalong. Okay, I'm learning Japanese via the chat. Outstanding. Kawalong. Okay. Yeah. Teach Blackleaf Japanese. This is good. On February the 5th, called Funimation to make a statement about him being banned indefinitely, called Vic a predator. That's probably not defamation. I need to know more about how it was being called. Was that publicly? Then maybe. And predator, I don't know. Maybe. Over the next 24 hours, Florida SuperCon, Raleigh SuperCon, Comic-Con, and Hudson Valley Comic-Con all canceled Vic's appearances. Kawaii. Yes, kawaii. Very good. On February 6th, Ronald tweeted that Vic assaulted my fiance, implied Vic was a rapist, and called Vic a predator, accused over 100 counts of assault, and proclaimed he wanted Vic blacklisted and out of work. That would be both potentially defamation and tortious interference. Later that day, Jamie announced the name and shame was faster than legal to redress. Well, maybe faster, but, if it's not accurate, it leads to problems, right? So, yeah. Kawaii. Yeah. All right. In February 7th, 2019 email to Funimation's Trina Simone, Monica accused Vic of assaulting her. Ma immediately took to Twitter sphere to proclaim that Vic assaulted Monica, potentially defamation. That's a statement of fact. Other actors, statement of fact. Sexually assaulted Monica, her friends, and countless fans, statements of fact. Again, called Vic a predator. Probably an opinion, but yeah. On February the 9th, Jamie tweeted that Vic had assaulted her in Funimation's lobby by grabbing her hair, yanking it backwards, and whispering something sexual in her ear. Though he could not recall what said, they had done this exact thing to her. Hope Donovan Wisdom knows his predator. Well, presumably Jamie knows whether or not that's true or not, because it happened to her. So if it's true, it's true. If it's not, it's potentially defamation. So, did that happen or not? 2 days later, Funimation published 2 tweets. One, that following an investigation, Funimation will not be engaging in Mignoga in further productions. And 2, we do not condone any harassment or threatening behavior being directed at anyone. Yeah, so you can read that as in context. You can say the second statement is related to Mignoga, which was Ty's argument, although he blew it. He's trying to argue it's inferred from the context, which I think it is, but he blew the argument. Responding directly to Funimation's tweet, Monica commented on Funimation's Twitter feed that there are multiple investigations with testimony, proof, evidence. I'm one of dozens of men and women who participated, later tweeted, just so he's clear, he's the legal definition of harassment. Okay, well, yeah. Unsurprisingly, Funimation Twitter followers declared they understood Funimation was saying its investigation had determined Vic had engaged in harassing or threatening behavior. Which is good because you're showing not only could someone understand it that way, it was in fact understood that way. So you're showing that understanding is reasonable. Again, I don't remember this being particularly well laid out in the pleadings or in the argument. If this had been shown, that would have been really helpful, but I don't remember it. This is why I said, when I first read it, it seemed workable. I might have said the word plausible, but I probably shouldn't have gone that far. I probably should have said it's workable. You know, it's a workable complaint. These are workable statements. You know, this is workable defamation. This is workable tortious interference. You know, we need to work on it, but it's workable. And if it didn't get worked on and it all fell apart, well, yeah, that's kind of what I think kind of happened, seems to me. Hello, Swarley. Mignogna. I'm doing the best I can. We're doing the best we can over here with the pronunciations. You know, yeah. Mignogna, I think is right. On February the 16th, 2019, Ron implied Vic would have to be a registered sex offender. That's defamatory. 3 days later, well, it's potentially. 3 days later, Monica tweeted that Vic had been accused of sexual harassment, factual. Alleged Vic had assaulted her by grabbing her in the hair and whispering in her ear, factual. Claimed she witnessed him do it to many other people, factual. Claimed he had forced a kiss on her in the mid-2000s, factual. And called him a predator, probably opinion. Yeah. Lemon Party says, if the case is workable, shouldn't it have passed the prima facie bar of TCPA? No, not necessarily. No, absolutely not. No, no. You're not understanding me, or I'm not explaining it properly, and I will blame myself because I think in any communication, you should hold the person speaking primarily responsible for communicating, not the person listening. So I'll accept responsibility. When I say something is workable, what I mean is I read it and I'm like, okay, well, here's some things that look like they could be, if they're shown to be, that would be fine. But, you know, in full knowledge of the TCPA, you know, I'd want to work on it. I'd want to perfect it, to use another legal term. I'd want to make those better. I'd want to bring in more evidence. I want to do as much research in advance as I can, because I know the TCPA might interfere with my discovery. And I'm the plaintiff. I'm in charge of when I file. So that's the nice thing. I'm in control of the case because I'm the plaintiff. So I'd want to hold off filing and get as much as I can from as many people as I can. I'd want to ask for any statements from his personnel file. I want to get statements from any of the conventions he'd go to. Like, here's what I would do. Like, if I was his lawyer, if I was Vic's lawyer, and he came to me with this, first of all, I'd have to know when is my statute of limitations deadline, because that's obviously going to be a huge barrier to this. Like, if my statute of limitations deadline is tomorrow, I have a real problem. Then I have to advise my client about all the weaknesses we're about to suffer and then file and hope for the best. But if I have time, then what I want to do is, okay, give me a list of every convention you've been at in, say, the last 5 years. Give me a copy of every email or every letter you've ever received from any of the people you worked at with the conventions that said, we really enjoyed having you, hope to have you again, or any emails that you have that say, when are you coming to our next convention, or why have you signed up for your next convention, or are you available? Like, all that good stuff that shows interest, so that I can show, oh, these are the specific contracts they interfered with. These were the specific things we had a reasonable probability of believing would come to fruition, but for these actions. Here are all the things we did in the past. Here are all the negotiations that we had that were ongoing. Here's all the statements from the people that said that they were really looking forward to them. And oh, then by the way, here's what happened and all those fell apart. So that would have been really good. And the same thing with like the defamation. It just was not made good in the pleadings. He filed a bare bones complaint. It was not well argued. So workable and past the TCPA are not the same thing. I don't even know. I'm not even necessarily saying that it could have passed the TCPA, because workable is not saying, oh, it would have done it, but for. I don't know that. I'm just simply saying it caught me as something that, like, oh, if someone came to me with this hypothetical fact pattern, I'd be like, oh, I have enough in good faith to go forward as an attorney and try to investigate this. You know, I have enough to at least ask questions. You've come to me with something that seems workable. Is it enough to get past TCPA? We're going to find out as we work on it. But no, those are definitely not the same thing. And yeah, someone said Easy07 said, doesn't TCPA stop discovery? Yes, it can. And it's precisely for that reason. It's precisely for that reason. That if I'm the plaintiff and I'm aware of TCPA, I want to do as much as I can before I file. You can't stop discovery of a lawsuit that hasn't started yet. You can't stop me discovering, in a lawsuit that hasn't been filed. So, I don't have all the benefits from a court in terms of subpoenas and formal process. So I don't have formal discovery, but I can send letters on legal letterhead and be like, please to, I can either be really nice or quasi-threatening about it. And either way, I can get information before I file. So yes, the very fact that TCPA would prevent discovery would be exactly the reason I'd want to do as much as I can before I filed in the first place. Because I'm the plaintiff, I'm in control of when I file. So me being well aware of that, I was like, I want as much as I can before I file. Yeah. That is the problem. Yeah. Yeah. So Vic consistently denied the allegations in large amount of income. Vic sued appellees for defamation, tortious interference, and civil conspiracy. He filed a motion to dismiss. Vic moved to strike. The trial court denied motions to strike. During the motion to dismiss and in its October the 4th, 2019 order, the trial court indicated it would not consider anything filed by appellees after the 60-day TCPA filing deadline. Okay. Vic filed a written response to appellee's motion to dismiss and amended and supplement his petition. However, the trial court refused to consider his amended and supplemental petition. Okay. Why? Why did the trial court fail to consider it? What deadline did they fail to consider, or what was the basis for failing to consider it? There's a lot of reasons that could have happened, so tell us more. After a hearing, the trial court granted the motion, the trial court entered final judgment and sanctions, and now we're into the lawsuit. Yeah. Yeah. Trial court committed reversible error, dismissed, okay, blah, blah, blah. All right, so let's go to argument. All right. A motion to dismiss involves 3 steps. Movement must show by preponderance that non-movement's claims are protected. If that burden is satisfied, the non-movement must establish a prima facie case for every essential element against the defendant by clear and specific evidence. See, this is exactly why, right? This is exactly why I want to do as much as I can. Clear and specific is more than preponderance. It's less than reasonable doubt. It's somewhere in between. If preponderance of the evidence is 51% and beyond a reasonable doubt is 95, then clear and, this clear standard is probably like 70, 75. This is exactly why I want to have as much as I can, because it's very clear that, like, on the surface, it goes to protected interest because it's speech, right? So I want to have enough to get over that burden. Right? Here's a whole bunch of evidence I have. Seems clear. It's enough to get me past the hurdle, right? I don't want to have to deal with a discovery freeze and then deal with me trying to prove it. I want to get as much of my case forward as I can. A prima facie case requires a minimum amount of evidence necessary to support rational inference. Yes. Clear and specific evidence is not a heightened standard. What? Clear and specific evidence is not a heightened evidentiary standard. Rather, it means non-movement must show enough detail to show factual basis for claim and support a rational inference that the claim is true. What? I would like to take note here that in his quote marks, the words "not a heightened evidentiary standard" is not in quote marks. Let's all observe this together, that it's not in quote marks, which means it's characterization, right? So clear and specific evidence must provide enough detail to show factual basis for a claim and support rational inference for the claim is true. Okay. Then he says, well, that's not a heightened standard. It's a heightened standard, in my humble opinion. Unless there's a case exactly saying this is not a heightened standard. And even then, I'd probably say it's a heightened standard, even though the court said it's not. But yeah. The court considers live pleadings as well, supporting and opposing affidavits, supporting the claims. Yes. A stage presumes the truth of the non-movement. Yes. I don't need 5 citations to tell me that. I knew that. favors conclusions of the claim are not predicated on protected expression. That I would need a citation for. The non-movement is not required to provide direct evidence. That's true. You don't ever have to provide direct, although it's very helpful. Instead, you may rely on circumstantial if the inference drawn is reasonable. Yes. Vic met his burden to establish prima facie for each evidence by clear and specific evidence. He was required to provide a minimal quantity of evidence supporting rational inference that appellee published false statements that defamed him with requisite degree of fault regarding the truth, negligence for private individuals, actual malice for public figures. Sure. And damages. Pleadings and evidence that establish facts of when, where, and what was said of defamatory nature and how they damaged are sufficient. Okay. Vic claimed Jamie defamed him by publishing false statements. He showed that on February the 9th, 2019, Jamie tweeted that he assaulted her by grabbing her hair, yanking her back, and whispering something sexual in her ear. She continued to know that he had done this exact thing half a dozen other women, and he's a predator. Vic specifically denied that denied he did this to Jamie or anyone. That is clear and specific evidence that Jamie's publication was false, and he knew it to be false. Falsely accusing someone of a crime or engaging in serious sexual misconduct is defamation per se, obviously harmful. Vic established prima facie case of defamation against Jamie by clear and specific evidence. Trial court committed reversible error. A little thin. Vic claimed that Monica defamed him by communicating and publishing false statements. She showed that Monica told Christopher Sloch that Vic was a sexual predator and criminal charges would soon be filed against him. Not clear it's defamatory. Isn't Christopher, because Christopher Sloch is like someone in Funimation too, right? So this is also a privileged communication because it's going to someone inside the corporate structure of the same company. There's actually some cases, and I don't know that Texas does it this way, that will say that this actually doesn't qualify as speaking to another person because it's part of the same corporate enterprise. And because corporations are people, therefore they're all the same person. But that's another way of looking at it too. So it's privileged communication. And it's probably not defamatory. He showed that Monica accused him of assaulting her in an email. Okay. He showed that Monica publicly declared that multiple investigations. He's the legal definition of harassment. Okay. That seems more on point. And showed that on February 19th, Monica tweeted that Vic had been accused of sexual harassment. He assaulted her by grabbing her hair and whispering in her ear. Vic specifically denies the accusations. It's clear and specific evidence the publication was false. And newer publication was false. Monica's accusations were defamation per se. I don't really like the blending of the privileged and non-privileged statements here. I would have broken those up into like two separate subheadings because it has a way of tainting the better stuff. When you put weak stuff and strong stuff together, it's like putting a bad apple into a bunch of apples. It doesn't make the bad apple better. It makes the good apples worse. So like if you have a bunch of stuff that is probably not, and then one that is, it makes the one that is look weaker. So I would have written that differently. Or not mentioned it. Vic claimed Morrell defamed him by communicating and publishing false statements. Told Christopher Sloch that Sloaney was conducting an investigation into Vic assaulting 4 women. Criminal trials would be soon. Funimation was not investigating Vic assaulting anyone. Oh, is she? This is where he's going to get really precise about the word assault. No, I'm sorry. No, not for our purposes. No, like, you know, if you're saying harassed or whatever, and you're saying, oh, she used the word assault, and it's not assault because it doesn't meet the definition of assault. Like in this context, it's not what we're looking for. No, but thank you. No. Ronald does not work for a law enforcement agency, so he could not know criminal charges being filed. That doesn't follow. Just because you don't work for law enforcement doesn't mean that you can't know that criminal charges aren't being filed. Like, lots of people who aren't law enforcement know that. Yeah. Either Raul knew what he said was false or acted with reckless disregard. That doesn't follow. And falsely accusing someone of a crime or engaging in sexual misconduct is defamation per se. Strictly speaking, they didn't accuse you of committing a crime. They said criminal charges are being filed, which is different. So, no. Vic also showed a tweet that says, I know with 100% certainty that they assaulted 4 people I love. Okay, see, now that is a lot closer. Because you're not making the statement inside the privileged envelope or inside the protected envelope of the communication. You're not making the report to like HR. You're not making the report to your boss. If you're making a public statement now about assault, people are going to read that as assault. So that is a lot closer to defamation. Yeah. Raul knew of at least 4 assaults. Raul testified that 4 people and 4 assaults to which he returned were 2 adult women and a coworker about whom Miss Dunn asked, and presumably herself or someone else. Vic showed Raul the tweets. Raul admitted he was not present. 2 adult women are the coworkers, so you cannot know with 100% certainty that Vic assaulted them. Does that make it like recklessly disregarding the truth? No. Plus, Vic has denied his allegations. No. This stage is clear and specific that he knew it was false or acted with reckless disregard. Falsely accusing someone of a crime or engaging in serious sexual contact is defamation per se. Yeah, I also don't like the fact that he's completely ignoring the public figure aspect of this, which is like not a trivial aspect. Right? He's treating this like a straight line defamation claim against a private figure. But the court below, as I understand it, ruled him to be a limited purpose public figure. That is now the posture of this case, right? Regardless of what you want to be true as a lawyer, that is the factual posture of this case. So you have to own that factual posture, and you have to argue in light of that posture. Now, there's certainly lots of ways to do that. There's certainly lots of ways to do it, but ignoring is not really one of them. You can't just pretend the trial court didn't say that or not address it. It makes it look like you're hiding the ball. You need to address it up front and be like, you should probably brought it in first. The better way to do this, if you're going to do this, is you should have dealt with the public figure stuff first and then dealt with this later. You shouldn't have done it the other way around. So I'm not a fan of that structure because I and everyone else in the back of their head are thinking, but this is a limited purpose public figure. So this isn't even the right analysis anyway. And he keeps ignoring it, and it makes it look weak. You don't bring attention to things you don't want made attention. And someone who, knows what they're reading notices that you're not bringing attention to it, and then it brings more attention to it anyway. So you got to figure out ways to do it more creatively. I don't really like this. Yeah. Vic showed the tweet, sexual assault implied to be a registered sex offender. Okay, we kind of covered that. He's not a physician or mental health expert with a man of clear history of sexual deviancy. That's not an expert opinion. It's a layman's opinion, and I'm not sure it's actionable. Because what does deviancy mean? Everything's deviant to somebody. Vic has never been charged with, or much less convicted of, assault. Moreover, he's publicly denied the allegations. This is clear and specific evidence. No. I don't know. This isn't working for me. Yeah. Vic claimed that Funimation defamed him by publishing statements about him that, when viewed together, conveyed in false defamatory meaning. Individual statements published together can convey false meaning. Juxtaposition. Yes, that's fine. Here, a court examines the entire publication. That is exactly right. Not individual statements to determine defamatory meaning. That is also true. The question of whether the words were reasonably capable of defamatory meaning based on how a person would perceive them as a whole. Right. And this analysis is helpful to ask whether the statements published were more damaging than truth. Yep, that's a fair statement of the law. I'm down for that. Vic showed Funimation published 2 statements stating, following the investigation, we do not condone. He showed that Funimation's Twitters understood that it conducting an investigation and deemed him engaging in harassing and threatening behavior. Yeah, I agree that was the implication. Yeah, that could have been done. I think he flubbed it, but yeah. However, prior to the tweets, Vic had denied the allegations. The investigation did not determine he engaged in harassing and threatening behavior. I think it kind of did. I mean, it doesn't mean it was right, but yeah. Funimation never clarified its investigation, did not conclude that he engaged in the behavior. I think from their perspective, he did. And I think their perspective of what constitutes harassing and threatening is really absurdly low. But, yeah. Vic showed Funimation standards published together conveyed false and defamatory meaning. Funimation knew this conveyed meaning was false. Falsely accusing someone of crime is defamation per se. Vic nonetheless showed they suffered damages. Okay. Vic met his burden by clearing specific evidence for each essential evidence. No, he really didn't, at least in his argument. So we're dealing with tortious interference. Okay, let's say if he wants to tell me what contracts. He required me to produce minimum quantum of evidence that the contract appellant knowingly intentionally caused interference caused and he incurred damages. Vic showed he had a contract to appear at the Comic-Con convention. And he cites a footnote from the record, which I don't have a copy of, but we'll take his word for it at the moment. He showed, well, I don't know that we should take his word for it, given like what we saw at the oral arguments, but yeah, I still don't have it in front of me. Showed that Ronald and Monica telephoned and texted Christopher Sloch, defamed Vic, and demanded. Okay, if you actually showed that, that would be great. Showed in response, he canceled the appearance and showed that he was unable to attend only after encouraging legal fees. Vic showed they had written agreements to appear at several other conventions. For example, why not just like say them all? Why not just delineate all of them? I don't like this for example stuff. Why not just say here are all of them? Here are all the agreements. Why for example? Just tell me all of them. He showed Jamie and Funimation knew of, and if you're worried about like it being not because there might be others you don't know about, you could say at least as much of, but not necessarily limited to 1, 2, 3, 4, 5, 6, 7. And there's an eighth, you can add an eighth later. But list them all. Why not? He showed that several of these conventions canceled appearances, breach of contract because of the statements. He showed actual damages. It was a little thin on the oral argument. The judge asked, like, what contracts, and you were a little bit like, and you're a little bit like, here too. What contracts? What specifically, what contracts? And what did they exactly say? You're referring to, like, I also don't like that he's not, like, quoting, like, specific language, like in the footnote or otherwise. He's citing, which is fine. But if, like, someone said, I had a contract with X, why doesn't he just quote it directly? Presumably because it's not there, is what I'm guessing. You know, he wants people to read between the lines. So, yeah. Vic established a prima facie case. Trial court error with prospective relationships. Which relationships? Previously appeared and fully expected to participate. Why not list them all? Why not say, for example, he expected to participate in the following conventions? 1, 2, 3, 4, 5, 6, 7. Why not just list them? The conventions did not invite him. 6 conventions canceled. Why not list them? He cites a footnote, but why not just say, here are the 6 conventions? Why not put them in a parentheses and a parenthetical in the footnote? It was reasonable to interfere. Appellees were substantially certain that defaming publications will result in further cancellations. Vic met its burden to establish by clear preventing for vicarious liability. Liability for another are imputed because of relationship. Employer is responsible for those under the employment. Supervisor liability arises for harm caused by an independent contractor where the employer retains some control over the manner in which the contractor performs the work. Interesting, because that was not my understanding of the law from Funimation's lawyers. So I'd have to actually get deep into this issue in the Southwest Third case, because they seem to be arguing the opposite proposition for independent contractors. Vic was required to produce a minimum quantity of evidence supporting a rational inference that Monica and Jamie were employees or Funimation retained control. Vic showed Funimation controlled when and how she performed her job, that she used Twitter account for the job. She sought Funimation approval of what she could say in the public arena. Clear specific evidence that Funimation retained some control. Given this evidence, it's reasonable to infer that Funimation over Jamie's work, subject to supervisory liability. I have to get actually deeper into the case law to figure out if that's true or not, because Funimation cited law that went the other way around. My understanding was it was the other way around in Texas law. So I don't know if this Southwest Third case is how good authority that is or not. So Vic Shobaka acted was treated like an employee. That's not going to work. She reported her allegations to Saw Assistant Funimation Human Resources just as an employee would. Her concerns were forwarded to company's employee relation executives. That's not going to work. Monica testified she used Twitter for her job and sought Funimation's approval. If you could show like that as a historical practice, yeah, that might work. She described Funimation as her workplace. So does everyone. In fact, Ron even tweeted that Monica was a Funimation employee. Yes, people are not always 100% precise in their tweets. You know? Amazing. Provide technical services? Okay. An agent's authority to act on behalf of principal depends on some communication by the principal through the agent or to a third party. Okay, great. Yeah, agent, principal, responsibility. Sure, no problem. The principal controls the agent. The agent is responsible for things the principal is responsible for things they tell the agent to do, and the agent does. Yep. Monica sought Funimation's approval of what she said. Despite Monica's false signal boosting, there was multiple investigations, testimony, proof, evidence. I'm one of dozens of men and women who participated. Despite Funimation's Twitter followers understanding Funimation Monica to say his mobile investigations to determine Funimation never clarified a statement nor contradicted Monica's. This is clear and specific evidence that silence continued its affirmations. That's always a problem at best. Using silence of any kind to show anything is a problem in law, like just generally. You know, showing any kind of acceptance by silence, no. No. Vic was the very definition of harassment. She did so clothed with... Ooh, I like this language, though. She did so clothed with the indicia of Funimation's authority. I like that language. It's nice. You could have made it even a little bit fancier. She did it with the imprimatur of Funimation's authority. That would be even a little bit spicier. But I like that. Clothed with the indicia. That's nice. Okay. Given this and the fact that Jamie held virtually the same position, it is reasonable to infer they acted with apparent authority. Alternatively, showed with acting with apparent authority. No. Relevant inquiry is whether there's a connection and there's tortious conduct. There may be such a connection even if the employee performed negligently or is promoted by ulterior motive or animus, so long as the conduct was pursuant to his or her responsibilities. Sure, no problem. That is not a problem, right? If it's part of your job responsibilities, the fact that the employee themselves also has independent motives is like not relevant because the employer told them to do it. So like the fact that the employee really, really wanted to do it is kind of neither here nor there, right? Because the employer told them to do it in either case. So whether or not the employee wanted to do it is kind of doesn't matter. Employees' defamatory statements regarding the individual being investigated have been found to meet this threshold. See a case, which, you know, as all cases, we have to go to its specific facts and specific fact pattern to figure out how analogous it is. Reversing a take-nothing judgment against the employer under vicarious liability because the filing was against a great weight of evidence in regard to scope. Well, if that's the legal proposition you're looking for, I don't think you're there, man. I don't think you're there. I don't think we have anything resembling the great weight that is going the other way. No, I'm not seeing that. No. Also, I should point out that a lot of these are factual questions, right? Lest I have to point out the obvious. Like, a lot of this is factual questions. Like, were they acting in the scope of their employment? Were these things that their employer told them to do? Did the employer have control over them? These would be questions of fact, not questions of law. The trial court is the one that answers facts questions. Like, did this person tweet this thing? Were they doing so in their official capacity? Did the employer tell them to? Or did they not? Or did they whatever? It's like, those are factual questions. Appellate courts don't do facts. Appellate courts do law. Trial courts do facts. So if you want, if the trial court said, this is not the facts, then you have to show, if you want the appellate court to say, you're wrong, trial court, you have to show, like, basically blatant disregard of all these other facts. Like, because how much the facts should weigh and how much they should matter and how much they should balance is a judgment call for a juror, whether that's literally a juror or the judge acting as a juror. The trier of fact is another way to put that, right? So, like, I've said this before in criminal cases even. Like, if you have one witness who says, I saw him do it, and 10 witnesses who say, I know for a fact he did it because he was with me at the time, here's the question. Can the jury find that the person did it? Yes, they can, because the fact that you had 1 to 10 or 10 to 1, or the other way, you have 10 witnesses who say, I saw him do it. And one witness says, no, he didn't do it. He was with me the entire time. And the jury says not guilty. Can a jury do that? Yep. Yes, they can. All they have to do is disbelieve the other 10 people. They can do that. That's what juries or finders of fact do. Here's a whole bunch of evidence that points to a whole bunch of things. Do you believe it or not? I don't believe these 10 guys. I believe this one guy. I don't believe this one guy. I believe these 10 guys. Okay, here's a whole bunch of evidence that suggests they were employees. Here's a whole bunch of evidence that suggests they weren't. They're not employees. That's a factual determination, not a legal determination. Here's a whole bunch of evidence that shows they were acting in their official capacity. Here's a whole bunch of evidence that says they're not. They weren't. That's a factual determination, not a legal determination. That's what trial courts do, right? They weigh the evidence and they consider it. And they try to say, well, okay, here's how it all balances out. And they're on this elevated standard at this point because of the TCPA. So you have to show clear and convincing evidence, which Ty's lawyer says is not a different evidentiary standard, which I'm like, unless he's using the word evidentiary in a very pedantic way. Unless he's using evidentiary in a very pedantic way, which I guess is possible. Unless he says it's not a different evidentiary standard because it's a different pleading standard. If he's being that pedantic about it, then sure, it's not a different evidentiary standard. Okay, you win, Ty. It's not a different evidentiary standard. It's a different pleading standard. But that's so pedantic, it didn't even occur to me to make the distinction when discussing it. But yeah, you're under this elevated pleading standard. And, if you're not there, you're not there, which is why you should have done more in advance. And as the trial court saying, well, did you pass the threshold or not? If not, case dismissed. It's what the law requires. So, okay. Yeah. Monica prompted and participated in the investigation. Both Monica and Jamie published tweets accusing Vic of assault and referenced Fundation's investigations and tweets. The question presented is whether Monica and Jamie, as employees who utilized the accounts to further the business, acted within scope of employment when they published. Yes, that is the question. It's a factual question. The record shows that Funimation acted in concert with it. Well, the record may reflect that, and the record may reflect the other thing. Which, again, that's one of the things trial courts are for. Put all the evidence in one big hopper and figure out what the heck it tells you. It'd be disingenuous for Funimation to argue that social media does not promote Funimation's business interests. The accounts existed for that purpose. Okay. Yeah. Whether Monica and Jamie are acting as employers established by clear and convincing, apologize, clear and specific, clear. I keep making this mistake. And you'll have to forgive me. I apologize. Because clear and convincing is an actual evidentiary standard. So clear and convincing is a standard we use when we talk about like reasonable doubt, rational basis. We talk about clear and convincing. So I keep messing it up because I'm so used to saying the phrase clear and convincing. But that's not the phrase. It's a different phrase here. So bear with me because we're in a different world and I keep having to correct myself. So I'm sorry. Clear and specific, not clear and convincing. Okay, thank you. Yeah, and anytime I say clear and convincing, just read clear and specific. So that's my bad. The trial court erred by dismissing the civil count because it's not subject to dismissal under TCPA, and Vic nevertheless established a prima facie case. We can't have conspiracy without something underlying. So without the underlying conspiracy to do something, you can't have a conspiracy. The claim is not subject to TCPA because they were not in furtherance of a common interest. They might be. The court has previously held that TCPA's protected right of association requires expression, promotion, pursuit of common interest, which implicates more than narrow selfishness of a person who acts to commit a tort. Yeah, well, yeah, but if it's not tortious, see, that's the problem. There are selfish interests of people who act to commit the tort. You have to have the underlying tort. So you can't have a conspiracy without the underlying tort. So yeah, if your underlying torts fail, the conspiracy fails. The conspiracy to do what? In order to trigger protection, it's defendant's burden to show by preponderance of credible evidence they're acting in concert to promote, pursue or defend an interest, not merely their own selfish interests. I don't think that's too hard. Right? If you, I mean, at least on their surface, excuse me a second. At least on a surface level, the tweets do serve a common purpose and a common legitimate purpose, arguably, because if you really believe that Vic did all this stuff, then they have the common purpose of outing a bad person from their circles, which seems pretty legitimate, right? So if you believe Monica at all, and then they were participating in common factor. So, okay, seems plausible if you believe them. Hence, the TCPA is not a shield against the conspiracy because they're pursuing their common interests. It's afforded protection. At the outset, Pelley's public comments refer to events that, had they occurred, would be private matters between the complainants and Vic. No. Just no, Vic. No. I'm sorry. I cannot give you that at all. No. No. They refer to events that, if occurred, would have been a private matter between Vic and you. No. Look, I'm sorry, man. But if it's true, and you come after me in some way, I kind of have a right to tell people about it. I kind of have a right to make a stink. If someone else says has this happened to me too, I kind of have a right to join with them in coming after you. So yeah, you might thought it's between me and you, but I don't have to leave it that way. What are you talking about? If it's true, it's not a merely private concern. That's ridiculous. No connection between their comments and public comments they reference. Make their accusations in the public matter via social media. Okay. No evidence of what happened between them was a common interest. This argument is lame, and it makes me sad. This argument is lame, and it makes me sad. I don't like this argument at all. This argument is turning me off in ways. I don't like this argument. This argument is, just as a way of aside, one of the things lawyers have to deal with when they're, especially on appellate arguments, is you have to worry a lot about bringing bad arguments or weak arguments into an appeal. And I've had this happen too, and I've had it go the wrong way for me personally as well. So it's one of the reasons I know this lesson. Just because you have 10 possible things to argue doesn't mean you should argue all 10 things. One of the things an appellate lawyer in particular should do is try to figure out which of them they want to bring forward. Now, that might be all 10, and it might be one. It's a strategic decision. Because, as I said before, when you have a bad apple in a bunch, it tends to ruin the whole bunch. So if you have 9 really good arguments and one crap argument, and you bring that crap argument in, it's more likely to ruin your 9 good arguments than strengthen the bad argument. So I don't like this argument. I really wish it hadn't been here. I wouldn't be making this line of argument. I think it's a strategic mistake, in my opinion. You know, is it legally correct? It might be legally correct, but lawyers don't always think only about the law. They also think about strategy. They think about who they're talking to, whether it's a jury, a judge, or anyone else. And they think about persuasion, and they think about what will be persuasive and what will not be persuasive. And to me, I read this and I'm like, you're arguing this is in public interest? I'm like, it's just like, and like a lot of your goodwill that you had for me is just going, you know? So I'm just telling you how I'm reacting to this. And one of the reasons that if I were handling this, this is one of the things I'd be worried about. And you always worry as a lawyer about not bringing something you should have, because, you know, if it goes against you, you're like, if I just brought that one more thing, I would have won. And I've had that feeling too. So it's a difficult thing to do. It's not easy. It's difficult. It reminds me of a line from J.K. Rowling where she said one of the things a good author has to do is kill your darlings, which by that she meant that you have to be willing to like edit and kill characters or kill lines, really good lines, because they just aren't working for your book. And lawyers have to do that too. They have to like, but this is really good, and they have to be like, no, I don't want to take that. So yeah, this is not working for me, man. This. Moreover, the trial court found nothing larger of common interest that they're pursuing or defending, acted together. Endpoint of conspiracy was to destroy his career. That sounds a little sour grapesy at the end of this. Provide no evidence, destroying his career is common interest. All right. Nonetheless, even this court finds the accusations were further in common interest, which I really think they were. Claims of conspiracy should not be dismissed because he provided a prima facie case. Clear and specific evidence. Each essential element. He's required to prove a minimum of evidence that 2 or more appellees seeking to accomplish the objective reach a meeting of minds, 1 or more unlawful overt acts. Your problem is not in the conspiracy. Your problem is in the underlying torts. So engaged in coordinated effort with and as I understand it too, and as I understand it from like some of the pleadings, there was a Discord, wasn't there? Wasn't there a Discord that like Jamie and like Monica and some of these other people were in? That was something called like the Bash Vic Discord or something really obvious like that. And for reasons that defy my understanding, it was not in the record. Now, I don't know if that was because it was submitted in an improper time or whatever, but that would have been really, really good. That, like, the Discord would have been fantastic. Why not get all the records from the Discord and put them in there? The name of it and all the participants and all the things they said to show the agreement and ongoing conspiracy. That would have been super. Why isn't that in the record? I don't know what the answer to that question is, and I don't 100% care, but the fact it's not in the record is making me like, I can't believe it's not on the record, because that would have made your case, you know, and it's not here for some reason. Why? It showed Monica's allegations, inhibited the investigation, kept automated. He showed Funimation could say publicly and shortly after conducted investigation, Raul maintained a continuous barrage of tweets. He showed Monica publicly urged Funimation. Again, this would fall into the category of things that you could have done before you filed your lawsuit. We're not talking about formal discovery, all right? We're talking about like informal discovery. So we're not talking with court orders, but you could have like gotten screenshots from the Discord, or you could have gotten someone on there to like copy like huge portions of Discord, copy the names and copy the like whatever. And, you know, you could have put that in a giant appendix. That would have been good. You know, which apparently didn't happen for some reason. I don't understand. And someone said Ty would have to subpoena it. Well, not necessarily, Mike Mitchell. That's what I'm saying. To get the official record of everything, sure, you'd have to subpoena it. But if you know it exists, because my understanding is he knew it existed at the time they filed their lawsuit. I presume there would be other ways to get it other than with a formal subpoena. I presume there'd be other ways for people to join the Discord, or other ways to get information out of the Discord, or screenshots or whatever, to show the Discord and show what it had. I'm presuming, hire a private investigator. That's one of the things they do. I'm presuming that a subpoena is not the only way to get evidence of what this Discord has to say or what its contents were. Okay? I'm presuming it's the kind of thing that you could have done some discovery on before getting subpoenas. So yes, ultimately you'd have to get a subpoena. Yes, I understand. But presumably a private investigator, someone could have found some record of it and put it in an appendix. Again, I'd rather have something rather than nothing. Here's some evidence. Then I'm going to go get other evidence, because now at least I have a basis. I have a basis to say, oh, geez, look at this evidence I have. Now I'd like all of it. I'd like a subpoena for the entire record, please. So again, seems like the kind of thing you could have done before filing a lawsuit. And again, plaintiff is in charge of the timing of filing the lawsuit. He's the one in control. So it seems like the kind of thing you could have done in advance. The reasonable inference drawn from the actions that Funimation, Monica, and Ronald conspired to defame Vic by falsely proclaiming, nor were the only statements defamatory per se, for which damages are presumed, but Vic also showed he suffered actual damages as a result. Vic also showed that prior to the defamatory tweets, Monica and Jamie had discussed how to harm him in private Discord, which would have been nice to have a record of. Not long after the discussion, they published virtually identical stories. In the interim, before and after the tweets, they repeatedly tweeted that they saw 4 friends, of whom they testified countless others. The reasonable inference drawn from the actions, Jamie, Monica, and Ronald conspired to defame Vic by proclaiming that they saw numerous women. I'm having a really hard time. Having a really hard time believing that there aren't private investigators out there who couldn't get copies of this stuff. Like, they would know the right places to look and right people to ask, or for heck, they could impersonate somebody. Be like, hi, I'm a victim of Vix too. I want to come onto this Discord and be like, oh, you sorry thing, welcome to our Discord. Have some roses. Whatever. Vic thus established by clear and specific evidence a prima facie case of Funimation conspired to defame. All right, the Second Amendment petition. 1 year to start? Texas of 1 year to start? That's possible. I would have thought it was 2 years if you didn't tell me otherwise, but if it's 1 year, then it's 1 year. But yeah, it's 1 year to start. So anytime I would have done something. Yeah. Yeah, it was dismissed with prejudice. It was dismissed with prejudice, so our only option is appeal. We can't start over. Our only option is appeal. Unless, of course, we can get the appellate court to, allow us to reopen it. But good luck. Yeah. There may be some screenshots. Yeah, I'll take screenshots. I'll take anything I can get. I'll take anything I get. Anything I can get on the front end in this kind of case is going to be helpful. Because I know the TCPA is a problem. I know the Discovery Shield is a problem. So I want to get as much as I can. Not for the least of reasons that having as much as I can is going to help me on the Discovery Shield issue. If I show, all the evidence I have, it's going to help me quite a lot on the Discovery issue, on the Discovery Shield issue, because I can show the court, hey, court, look, I've got all this stuff already, so I need formal discovery to perfect it, but look at all this, informal evidence I have. It's going to help me a lot in my argument. It's going to help me a lot in every way. So, if I have time to get it before I file the thing in Texas court, I'm going to wait. And if it's a year, then, and again, this is assuming I have time. Because it may have been the case that I didn't have time. because I don't know exactly when they're trying to get back to. I don't know exactly when this is filed. So maybe it's, and I don't know exactly when Vic went to a lawyer. So it might be that Vic showed up, 11 months afterwards and be like, I want to sue. And the lawyer's like, uh-oh, I don't have any time. If that's what happened, then I'm a lot more sympathetic. Now, hopefully his lawyer explained to him, because I don't have a lot of time here, here's a whole bunch of things that might happen, and explain like what will happen as a result. But, if he didn't have time, he didn't have time. But if he did have time, he should have used it. TCPA requires court to consider the pleadings and supporting opposing affidavits when determining whether legal action should be dismissed. However, the trial court refused to consider Vic's sentence amendment because it was filed within 7 days of the hearing. The trial court instead focused only on the amended petition response. The trial court's refusal to consider reversible errors. Okay. Generally, a party may amend its pleadings freely, but any pleading filed within 7 days of trial requires the trial court's permission, which shall be granted unless there's showing of surprise. Indeed, the trial court has no discretion to refuse the amendment unless the opposing party presents evidence of surprise or prejudice. The amendment shows a new cause of action and thus prejudicial on its face, and the opposing party objects. The allegations and claims were the same. The facts in it were consistent, belying any claim of surprise. Did they try to claim surprise? Therefore, the trial court had no discretion to disregard the Second Amendment petition conjunction. I don't have enough evidence to consider whether the trial court made a mistake here or not. I don't have enough evidence or enough information, I should say, to decide whether it's a mistake. If the rule again, my thing is like my natural lawyer instinct. Right, my natural lawyer instinct is try to avoid time issues when I can. If the rule says anything filed within 7 days, guess what I'm going to do? I'm going to try to file no later than day 8 to avoid this issue. So again, it's like, why didn't I? If I was ready to file on day 7, was I ready to file on day 8? Why not file on day 8? Because I'm going to give them one additional day of notice? Ooh, but I'm already risking this rule, So I file on day 8. Why wait till day 7? So, you play with deadlines, and sometimes you get burned. Sometimes you get burned. So, you have to be careful of these things, and you don't want to necessarily file on the last possible day or last possible hour. I still think you should have taken more time if you had it, though, on the front end, because of the nature of the case. Vic moved to strike because it's inadmissible. The trial court denied it to strike. Why was it inadmissible? 125. It goes to a footnote. Well, I'm not going up to the footnote to tell me why it's inadmissible. I don't know, but I'm going to just assume the trial court didn't make a mistake. Yeah. Vic objected to paragraphs of the affidavit as attached. The affidavit did not affirmatively show how she obtained knowledge of the facts alleged, thus failed to provide foundation for relevance. No. Ms. Mika testified about statements made by others from offered to prove the truth of matters asserted, which is inadmissible hearsay. No, it's probably not. It's going to show how she acted in response to it. I mean, I can almost certainly assure you without reading it that's true. I can almost assure you without reading it that it's not offered for the truth, but offered to show her response. Because look who it is, right? This is Vice President of Operations, okay? It's Vice President of Operations. And she in her affidavit is saying, here's a bunch of things people said. Okay, Vic is saying, aha, that's hearsay. It's an out-of-court statement offered for the truth of the matter asserted. And without reading her affidavit, I'm like, no, it's not. No, it's not. It's not being offered for the truth of it. It's being offered to show how she responded to it. So because she's the vice president of operations. So here's probably what her affidavit says without me reading it. It probably says something along the lines of, I heard reports of, or Monica herself told me of, or something along those lines of, Vic did XYZ, blah, 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 blah. Therefore, based on this, I did XYZ. Therefore, I conducted a hearing. Therefore, I did this. Therefore, I fired him, or therefore whatever. It's not being offered for the truth of the matter asserted. It's not hearsay because it's not being offered for its truth. It's being offered to show why the person did certain things or how they reacted to a certain thing. So without me even reading her affidavit, I can just tell from her title, she's VP of Operations. Why is she mentioning it? Because it goes to how she operated the business and the actions she took as a result. So it's not hearsay. I don't have to even read it to know it's not hearsay. That's sad. Paragraph 5 of her affidavit references negative Twitter posts and other sources within AMAQ, in addition to being inadmissible hearsay. No, it's not inadmissible hearsay. Stop saying this. Stop using that word. I don't think it means what you think it means. Please stop. She should have attached actual accusations rather than summarize their contents. This is not hearsay. It's not hearsay because it's not being offered for the truth of the matter asserted. It's not being offered for its truth, but merely how she reacted to it because she's VP of Operations. Yes, I saw this Twitter post. Yes, I heard this from Monica. Yes, I heard this from y'all. And as a result, I did all these things. It's not hearsay. Yeesh. In the fifth sentence, Ms. Denbo testified about statements made by others which were offered to prove the truth of matters asserted. Was it though? Was it? Was it? Further, her affidavit failed to establish her personal matters and thus failed to provide. Yeah. Fifth and sixth paragraph, Mr. Barreto testified about statements made by others which were offered to prove the truth of matters asserted. In paragraph 8, Mr. Barreto merely testified that exhibits D to W of Fundament's motion to dismiss were true and correct copies without testimony. He's the custodian of records, or otherwise has any requisite personal knowledge to establish what exhibit is, thus failed to establish the requisite for authenticity. For the purposes of an affidavit, probably I don't really care that much. You know, if it's a trial, I'll worry about it a lot more. And I don't necessarily even blame Ty for mentioning it here, but it's just like a little bit like, okay, is he technically right? Maybe. Is Ty technically right? Maybe. Yeah, this guy, I don't know who he is or what his authority is. He's not the custodian of records, assuming they have one. Although that doesn't necessarily mean he can't authenticate them because I don't know what they are. You know, these exhibits are. So if there are exhibits involving him, like his emails or something like that, something he would have personal knowledge of, then he can testify to it. You know, or because of his positional authority, he might know. So he can say whether it's true or not. And like, okay, and why am I like busting over this? Is the case going to rise or fall over this? I'm somehow doubtful. Funimation relied on this evidence to prove Vic is a public figure. His tweets are related to public figure. Well, I don't know that we need to rely on that to prove that. Vic himself has pretty much all but confessed he's a public figure. Or a limited purpose public figure. Right? It's part of his essential pleading. Look at me. I'm a famous voice actor. I'm in this role. And I go to all these conventions and have gone to these conventions for years and years and years and years. And I've participated on these panels. And I've participated in these breakout sessions where I appear before my adoring fans, where I take photographs and sign things. And I do photographs. And I've been offered money for this for years and years and years. And, people love me and adore me. Vic, the idea that you're a limited purpose public figure is not really a hard stretch. You're kind of there on your essential argument. So, I don't know what Funimation is relying on, but I'm not having a lot of problem. Vic objected to some more exhibits. The affidavit of some various people. Okay. These exhibits are out-of-court statements made by someone other to prove the truth of the matter. Are they, though? The affidavit of Robin Mitchell Blankenship Carroll is not relevant or material to the issue. It's offered as character evidence. I don't know. The affidavit of Kara Edwards offers character evidence to prove the Vic ad in accordance with character trait. How? Like, what evidence are you offering? I don't, like, it might be it might be relevant, it might not be. I don't know. I'm confused. They're not telling me enough to understand if this is good or bad. The affidavit of Lynn Hunt is offered as character evidence to prove Vic acted in consport. The affidavit of Fall Hakeem is offered as character evidence. They're out-of-court statements. The affidavit is offered as character evidence. Out-of-court statements. Affidavit is character evidence. Character evidence. Character evidence. Character evidence. Not relevant. Character evidence. Out-of-court statements, inadmissible opinion testimony. Well, it would have to be expert opinion. Otherwise, she's allowed to have an opinion. But okay, out-of-court statements. Out-of-court statements. Public figure. Again, this at this point seems so like. It seems so off point to me. It feels so tangential to the actual arguments. It's like, I don't know. I don't know. Maybe they're highly material. Maybe these are really, really important arguments, but you're not telling me why they're really, really important arguments. It's like, okay, there's some statements from some people and some affidavits. Okay. Fine. I don't know why it's a problem. Licky Glock gives me 10 Canadian dollars, best dollars, and says, could Uncle Blackleaf explain how being a limited purpose public figure changes things? Yes, Uncle Blackleaf can, because of your super chat contribution. Sure. So when you're looking at defamation law, you're looking to whether or not someone is a public figure or not. Times versus Sullivan is your case on point from the U.S. Supreme Court for that. And basically, if you're a public figure, and I'll get to your limited purpose in a second, if you're a public figure, you have to show actual malice in addition to falseness. So to show actual malice, it's a term of art. It means that you knew or should have known that your statement was false. So not only does it have to be false, you had to know it was false. So in other words, you had to know you were lying. So defamation, in general, is just any false statement will do. In public figure, you have to show that you knew that the person who said it knew it was a lie when they said it. They had actual knowledge it was false, or they should have known, in other words, willful blindness, that it was false. The difference between public figure and limited purpose public figure is that a public figure is public figure for all purposes, all contexts, all issues. So, and a limited purpose public figure is not. So, how could I make that relevant to this example? I don't know. Imagine Vic got in trouble because of something completely unrelated to his job, or he had a dispute regarding something completely unrelated to his job. I don't know. Insert your own hypothetical here, right? Just imagine he did something in some way that doesn't relate to his job, and someone is making an accusation outside of this work. Then it's not a public figure anymore. He cheats on his taxes, maybe. I don't know. That might be an example. Because it's not related to this. It has nothing to do with the issue. So I couldn't claim public figure status for that kind of a statement. unless it was public, unless he's true public figure, in which case I'm covered for everything. So a true public figure is usually your politician. President of the United States is your obvious example. So, that gives you a lot of latitude for that, and limited purposes only for limited purposes. So he's a public figure for the purpose of being a voice actor for the purpose of Funimation's tweets. That's basically the difference between public figure and limited public purpose. So, yeah. That's the difference. And either way, you have to show malice for general or limited purpose. The TCPA provides an order to pay legal fees only if non-movement claims are properly dismissed. Matt, please try not to ruin my hypothetical. I'm trying to give an example. Let's not pick apart the hypothetical, Matt. Try to be on my side, okay? Thanks. Appellees in a Appellees in a concerted conspiracy to destroy Vic published defamatory text, tweets, and emails about him, knowingly interfered in existing and prospective appearances and image the damage caused. When called to account for their tortious conduct, they sought protection behind the statute using inadmissible evidence which the trial court improperly admitted. Yeah. Made a prima facie statement. In short, the trial court converted reversible error. Well, I'm not feeling super encouraged by any of this, to be quite honest. This is not feeling like super wonderful. And we got a signature, and we got an appendix. This is order granting, so this is just the underlying motion from below, attached. That's fine. Is there anything else here? The final judgment itself for the amounts. So I guess we can just briefly look over that. Because $50,000, $7,000, and then these amounts. Fees, $100,000, $50,000, $40,000, $37,000. It's a lot, right? So it's like $500,000, something around that. It's a lot. Okay, that's the end of it. So that is the end of it. So I'm not super duper impressed. What would be considered liable proof from Ezra 007? What would be considered liable proof? Liable proof is not something that exists in every jurisdiction, but where it exists, it's a person. It would be a person who is of such unbelievably poor reputation that nothing more can possibly be said to hurt them. So it'd be someone like who is just completely like trashed. I'm loath to give an example of such a person, lest I be accused. But let's say Anthony Weiner, off the top of our head, or let's say Weinstein, Harvey Weinstein, or Jeffrey Epstein. These would be good examples, right? So these would be good examples of someone who's probably liable proof. Their reputation is such garbage that I could just make out lies and I can't be held responsible for it. Probably true. But it's not, I don't know that's accepted everywhere in every jurisdiction. So, but all of those people I just named are public figures anyway. So I'm covered by the normal rule of, actual malice anyway. But it was an example of someone who's so discredited that, it can't possibly hurt them anymore. So I hope that was helpful. I enjoyed that. Thank you for the $10 worth of super chats to people who joined me. I hope it was educational. If someone is dead, does libel no longer count? No, you can libel a dead person, I think. Damage to reputation, especially if their reputation is worth anything. Still dead. I mean, like Michael Jackson's estate, which is not a good example because, the guy has a poor reputation. But I think it's probably possible to defame a dead first person. I don't actually know. Can you defame an estate? I don't know. Probably. Yeah, but yeah, why not? Yeah, you're welcome for the song. So hopefully that was helpful, and it'll be interesting to see what Rakita says. I have nothing against Rakita. I don't know him. I think he and I would actually get along very well. It'd be interesting to see what his analysis is, but my looking over it, it feels like it's thinner in places where I feel like he has an argument, How do you get from limited to full size? Is size of the community? Matt Arnold says. How do you get from limited to full? Oh, you mean in terms of purpose? Limited purpose versus full purpose? No, I don't think it's it's I don't know. There's an easy way to describe how you get from limited to full purpose. I guess it's just full when it is, but I mean, politicians are your go-to example. Like pretty much any politician of any note, president, governor, senators, representatives, probably is automatically full purpose public figure. Um, because the idea of being public figure is you're injecting yourself directly into the public eye. Anyone who's like super notable actor probably qualifies. I don't think Vic is high enough tier to qualify. No disrespect to Victor, because I don't know that he wants to be high enough tier, because then he would be full purpose. So if he feels insulted by me calling him not full enough tier, then he can say, yes, I am full tier, in which case he's full-time public purpose, and then we can just ignore this entire argument. But yeah, I think, for people who are just really, really in the public eye, super notable, has your face ever appeared on a copy of a tabloid? Then you're probably a full-purpose public figure. So there you go. Yeah. Well, soon Press Law Center might have one on me. So there you go. Yeah. Yeah, there you go. But yeah, even a mayor might not necessarily qualify for all purposes. Like if you're within his town, or if you're the city newspaper, if you're the town's newspaper, then he's probably a public figure for all purposes. If you're the New York Times, probably not, because he's not public for all purposes. But if you're reporting on local news, yeah. But the mayor's probably not big enough, unless you're the mayor of like D.C. or New York or Los Angeles or Chicago. Then probably yes, because you're so big. But that's, yeah. Will I cover the George Zimmerman defamation case? I might. Yeah, didn't he's got no cause of action. I know he's broke. I know he's completely broke, but he has no cause of action. But yeah. Yeah. Public figure has a lot of flex. It does have a lot of flex. It is flexible. It is flexible. Yeah. Yeah, I know, again, no disrespect to Vic, but I didn't know who Vic was until this case came about. So it'll be interesting to see what Rakita says on it. Yeah, I think Rakita and I will get along very well. Yeah. I try to be fair. I try to be fair to both sides. I just try to be fair when I see something for Vic that looks fishy, or something for Monica that looks fishy. Either way, I say, oh, this is crap. And I said that about some of the stuff where I was like, I wouldn't make these arguments. I think they're bad. I think they're off-putting. And I think my sort of view on this, from where I'm sitting, and I haven't read everything. I read the original complaint. I read the original response. I read the original TCPA motion. I read the response to the TCPA. I read the oral transcripts. I haven't read everything, but I've read a lot of it. My impression, sitting away, is that his trial counsel flubbed the case. I think some of this is colorable. I think some of this is workable. And it just feels to me like he flubbed the case. It feels to me like he didn't have, here are the exact things I was taken out of. Here are the exact contracts that were killed. Here were the exact contracts I expected to have. Here's all the statements, and here's what they said, and here's an affidavit, and if not the affidavit, here's the email from this guy. Here's an email from each convention director. I'll take anything I can get. A phone call with them. If I can get a phone call with them, I'll transcribe their phone call, put that in an affidavit. I'll put it in an affidavit. This is what they said to me. If, anything I can get, this Discord or parts of it, it just feels to me like it wasn't well presented. It feels to me like it was flubbed. And I especially got that feeling given how the original complaint was written, because it was written in a notice pleading style, which again, it's legal, but when this TCPA stuff is coming, it just feels like it felt unprepared. And I didn't really see where it got any better than that. So, my assumption going into this, and whenever Monica and their team files their response, I'll cover that too on this channel. Whenever they file the appellee's argument. Whenever we hear that, I'll cover that too. And we'll see what they have to say. But to me, it just feels very thin. And so my assumption going into this is that Vic is going to lose his appeal. That's just, that's what I think. I think he flubbed the case. I think the trial court lost patience with Ty at some points. That's just what I think. I think, he's decided to stop maybe the trial court should have admitted that second amended thing. Maybe they should have. But maybe the trial court didn't want to because he was just tired. Because he felt like he was being bounced around and he didn't want to do any favors for this guy. If I had to guess, that's probably something along the lines of what happened. Just because it seemed that way from the oral argument. It seemed like he was losing patience. So, I just don't see any obvious error here. And I don't like throwing everything at the wall. When I see he's got 8 causes of error here, none of which are particularly great, none of which to me are like screaming that, oh yes, this demands redress, and some of them are pretty weak. I'm like, I'm just not feeling like it's going to go anywhere. So, yeah, Mike is right. The fraud and the notarization probably didn't help either. Yeah, that was not good. And could I see a trial court taking note of that and then wanting to penalize you endlessly for it in every possible way? Yes, I could. Is rule number one of court, don't piss off the judge. Don't piss off the judge. Yeah. So it just feels like there was some things where things weren't being done right, and it felt like it was more than one thing. It felt like the trial court just kind of lost its patience along the way, and the trial court just kind of gave up at some point. Which I have to tell you, if that's what happened, the appellate court's not going to do anything about it. If the trial court kind of gave up halfway along the way because you drove them to it, the appellate court's not going to help you out. So, don't piss off the court. I don't even know what rule number 2 is, but rule number 1 is don't piss off the court. Yeah. So, anyways, I'm going to sign off for now. If you enjoyed this, please give it a like. I also have posted a video today. I think it posted while we've been chatting because it was scheduled to post. Today's video that was scheduled to post and has posted was a good one. It was a guy who was appealing his criminal conviction. He was convicted of making true threats against the former Attorney General, Eric Holder. And he said such things as, I am going to kill you. I am going to murder you. He said this on voicemail as he identified himself by full name and the city and state in which he lived. He's unhappy because he feels the court below didn't have enough to convict him. So that was today's story. For all you who want to check that out, I thought it was pretty interesting. So you can find out whether or not it's okay to, on a voicemail, to the former Attorney General say, I'm going to kill you, I'm going to murder you. Spoiler alert, it didn't go well. So, yeah. Yeah. So that was the story that posted today. And until later, my friends, I hope all's well. Until later, cheers and goodbye.